Mr. Keneally.
SJC-12476, Commonwealth v. Christ O'Liss.
Mr. Long, good morning.
Good morning, Your Honor. May it please the court. This case really boils down to one issue, and that is whether Mr. Liss's circumstances were such that he had a reasonable probability of rejecting the plea and proceeding to trial if he had understood the immigration consequences of his plea. And the reality is that his circumstances were sufficient. And that's supported by the Supreme Court's precedent in J. Lee and by this court's precedent in Lavraninko, that's saying that the special circumstances test that we have for assessing whether a defendant would reject a plea and proceed to trial is not a rigid test of, these are the factors that might be special circumstances.
Can we take a step back to prong one of Safarian, though, and concerns Judge Agnes raised about the lack of an attorney affidavit, issues about whether or not the defendant had mentioned to plea counsel whether he was a U.S. citizen, presumption of professional assistance, and the information on the green sheet, which obviously in and of themselves, none of which are dispositive.
Yes. So Judge Harbour is entitled to deference on his factual findings that there was deficient performance because he was both the motion judge and the plea judge. So even in the absence of an evidentiary hearing to sort these issues out, he is in a better position than this court or the appeals court to assess Mr. Liss's credibility, to assess why Attorney Daley may not have provided the affidavit based on his observation of what occurred during the plea colloquy and also his familiarity with Attorney Daley's practice in his court.
Now, let's assume you are correct in that the fact that he has not, do we know, by the way, that he's not been back to Haiti since he was 7? I know he left when he was 7.
That is correct. He is not, well, he's been back now because he was deported, but at the time of his plea, he had not been back.
And is that in the record?
I am not sure if that is in the record.
All we know is that he left Haiti when he was 7.
Correct.
Now, the judge made a finding that there were no special circumstances. So let's assume for the sake of argument, your brother will challenge it, but we'll deal with that then. But let's assume for the sake of argument that you're right. Consequence is a remand? Or do you claim that you're entitled to a new trial based on that alone? Lavraninko says it's totality of circumstances, that the presence of a special circumstance, even a special circumstance, may not suffice itself, that you need to look at everything. What do you say is the remedy?
Well, I would say a new trial is the remedy in that situation, just because of special circumstances, at this point, it really is a legal issue, and there's not much benefit to it going back, or any benefit to it going back to the trial court to assess that issue. It's a question of, do Mr. Liss's circumstances count as special circumstances that would create that realistic probability of rejecting the plea?
Now, I'm sorry.
No, go ahead.
Go.
I was just, do you agree with the appeals court that it wasn't clear whether the motion judge was rejecting the special circumstances as special enough, or whether the judge was rejecting the affidavit from the defendant?
So I don't agree with that characterization because, in fact, the motion judge said that he did feel strongly toward crediting the affidavit from the defendant. So I don't think it's an issue of rejecting the affidavit.
So pragmatically, your argument is that the worst he would have gotten would be 2 years in the house. because of the school zone.
Not necessarily the worst, but the most likely outcome.
Right. So now, does it matter that under Commonwealth versus Bradley, the school zone, he would be entitled to the benefit of the 300 feet as opposed to the 1,000 feet? Although Bradley was decided after his plea?
I don't believe, well, I don't remember whether it was within 300 feet or not, but if it was not within the 300 feet, then that would matter, and that the school zone charge would then be, or school zone charges would then be dismissed, and so he doesn't have that 2-year mandatory minimum hanging over his head.
Now, you make no reference to the fact that at the time of the plea, individuals who left Haiti were entitled to temporary protected status. Would that itself be a special circumstance, given the reason why the federal government gave Haitians who left the country that status?
That could qualify as a special circumstance. Temporary protected status is based on the Department of Justice's judgment that conditions are so bad in a particular country that it's inhumane to force people to return there.
And what do we do about the fact that it was not referenced at all, best I can tell, at the motion for new trial hearing?
Well, because it is a legal question, I think this court can still decide it.
We can go back to one of the Chief's previous questions. I'm not sure I understand how we give weight to these special circumstances. Special circumstances are entitled to substantial weight, but going back to Chief Justice Gantz's point, it's the totality of the circumstances. We really don't have a calculus as to how all of this is weighed, so why isn't it a remand?
Well, I didn't hear the last part of that.
Why isn't it a remand?
Because Judge Harbour did believe that Mr. List wanted to stay in the United States. So it really was just that legal question of does this qualify as the kind of special circumstance that would cause him to reject the plea?
Well, I think what we have to decide is whether or not it's rational under all the circumstances, including that issue, rational to reject the plea.
That's correct.
Is that a finding of fact, or is that a ruling of law?
Well, that's a combination. There's a finding of fact as to what the defendant's circumstances were, but then there's a ruling of law as to whether it would be rational.
And you wanted us to give deference to the judge as to the ineffective assistance of counsel prong, but not as to this?
I didn't understand the question.
There's deference that you wanted to have us give to the findings that the judge made in connection with the ineffective assistance of counsel prong, but you don't want to have us do the same thing with the other prong.
Well, the difference is that I'm distinguishing between his factual findings and his legal conclusions. So he is entitled to deference on his factual findings, and in fact is entitled to special deference because he was also plea judge. But he's not entitled to deference on his legal conclusions.
And by legal conclusions, you mean his conclusion that there were no special circumstances?
That's correct.
Okay, now, in Lavrenenko, where he was here as a refugee, which we said was a special circumstance, we remanded. Why is this case more compelling than Lavrenenko?
Simply because I think the factual issue has been decided, and it's really just a question of, does this count as special circumstances?
Well, in Lavrenenko, we said that he was a refugee. That was not only a special circumstance, but one that was a special circumstance, and that warranted substantial weight. I don't know whether or not we would say that the age is equivalent, but why would, if we did not order a new trial in Lavrenenko and remanded to the judge to consider it based on the totality of circumstances, why are you in a better position than the defendant in Lavrenenko?
Well, if the court believes that there is a factual question on that that needs to be resolved, then remand would be appropriate. So I think that's I don't see a factual question, but the way to resolve a factual question would be remand.
Totality of the circumstances is not a factual question?
Well, I think that we know what the facts are that make up the circumstances, and it's
Who's
just a
going to weigh
question.
them? Who's going to weigh them? Who's going to weigh what goes into what the totality of circumstances means? Who's going to weigh that?
Well, I think this court would weigh
We do that.
what that means.
Would the remand, if there were one, include the analysis on prong one of Safarian based on Judge Agnes's analysis in the appeals court decision?
I don't think it would need to, again, because of the deference that's required to previous factual findings.
Well, it would be one thing, I mean, I think what Judge Agnes's point was, would be one thing if he said, I credit the defendant's affidavit. But I think he said, I have no choice but to credit the defendant's affidavit. And I think Judge Agnes says, no, you actually have a choice. Is that not another thing which the judge could consider?
Well, I read that as a splitting of hairs that maybe is not what the judge actually meant. And that what he really meant was that he found the affidavit compelling, and in a moral sense, he had no choice because he was persuaded by it. Certainly, I think he was aware that he did have discretion as the motion judge to make whatever factual findings he believed were accurate. And I think that Mr. Liss's circumstances are fairly similar to the circumstances in J. Lee. There's no questioning at the plea colloquy in a really obvious way, but there wouldn't be if Attorney Daly had read the green sheet to him, because he would have heard the warnings that the judge was giving him before. And as to any belief that he was a citizen, counsel is required to make reasonable inquiry on that question. And reasonable inquiry does not just mean asking, are you a citizen? It means taking it one step further, at least where there's this information that the client wasn't born in the United States, and asking, why do you believe you're a citizen? Because that's the question that really answers it. So if the client answers, well, because I was born in the United States, or because I remember that I naturalized on such and such a date, then counsel's not required to make a further inquiry on that question. But if the client gives a vague answer, so, well, because my dad's a citizen, so I guess I'm a citizen, that's something that would cry out for further exploration.
Now, if we do remand for a new hearing, could the Commonwealth subpoena Mr. Lee's attorney and have him testify as to what he remembered with regard to their conversations?
It could do that, and it could have done that previously as well.
Okay, so basically, if it's a motion for new trial, if we remand, then you would have a new evidentiary hearing, and the judge would be making new findings based on that record as well as the record below.
If the judge believed an evidentiary hearing was necessary, or if you ordered one, certainly.
All right.
I'll yield the rest of my
Anything
time.
further? We will thank you. We'll hear from Mr. Pell.
Thank you. May it please the court. Gabriel Pell, Assistant District Attorney for Middlesex on behalf of the Commonwealth. The Commonwealth is asking the court to affirm the denial of the defendant's motion for new trial where he has not satisfied either prong of the Safarian standard for ineffective assistance of counsel. And I would like to go, with the court's indulgence, to that first prong briefly and note that the motion judge only had before him affidavits from the defendant, the self-serving affidavits. And it seems like he erroneously believed that he had no choice but to credit those affidavits, notwithstanding established case law that even undisputed affidavits can be rejected and need not be found credible. I think that's an error of law in not recognizing his discretion.
But you didn't raise that below, right?
We did argue in the trial court that the judge did not have to credit those affidavits. And where Justice Agnes took it on his own initiative to address it in the appeals court, I believe it is properly before this court on further appellate review under the case law.
But how do we affirm on that basis? I mean, the best you would get is if that's the issue, we'd send it back to the judge and said, you erred as a matter of law, now you need to make findings as to whether or not you credit it.
I believe you can affirm on any basis that appears in the record under Vamang Joe and Commonwealth versus Lang.
How can we affirm, I mean, you say that, I mean, what you're saying is that the judge made an error of law in saying I must believe it, but how are we to make as a matter of law that the judge should not believe it?
I think it's then the next step that he wasn't required to credit the affidavits, but also even if he wanted to credit so much of the defendant's affidavit as stated that he didn't get the immigration warning, which we're not conceding, on this record that still wouldn't be enough as a legal matter before this court to satisfy prong one of Safarian, where the record before the motion judge indicated that if plea counsel had been there, what he would have averred in an affidavit, what he would have testified to, is that the defendant told him he was a citizen, perhaps on the basis of dual citizenship. And that if you look at it in that lens, the defendant didn't meet his burden as an initial matter on a motion for new trial to show that it was an inadequate showing, not just to warrant an evidentiary hearing, but to allow the motion, and that you could affirm it on that basis.
But that wasn't, I mean, I've read that portion of the hearing. That's not evidence. That's the attorney trying to say, I did my best to obtain counsel, and he said something about that, but if he were to have testified, I mean, that's self-serving too. So how are we to sort of say that constitutes evidence when it's part of defense counsel's description of the efforts she made to attempt to get an affidavit from him and his somewhat mealy-mouthed response that he thought he was a dual citizen and whether or not he made any appropriate due diligence to find out how that could have happened since he wasn't born here? I don't get how you can win on that.
I agree that that's not evidence, but where it's the defendant's burden on both prongs, I think that it is relevant to show what information did he put before the motion judge. And it's the defendant's own counsel making those representations. It's not clear how the motion judge could have found not just the affidavit credible, but that prong one had been satisfied on that basis. And if he hasn't found that prong one has been satisfied, that's the end of the motion.
Well, what's the defense counsel supposed to do? He put together the affidavit of his client, and he made good faith, he or she, I forget, made good faith efforts to obtain, which are described in the record of the efforts that he or she made to get counsel affidavit, and he wouldn't give it to them.
And I
so
think,
what are we expecting defense counsel to do?
I think what the case law states in that situation, what it's recognized is if motion counsel prepares an affidavit that says I consulted with plea counsel and he or she refused and states the reasons. Motion counsel didn't do that in this case, but had she, it would have been in an affidavit, presumably, that the reason, or at least one of the reasons why plea counsel didn't cooperate is because he said the defendant told him he was a citizen. That should have, or could have at least, been before the motion judge and would have been part of the calculus on whether prong one was satisfied.
You want us to draw those inferences, that whenever an affidavit's not available, the information would be poured to the defendant?
I think it's a permissible inference. It's certainly not a mandatory
Could be the
inference.
defense attorney doesn't just want to cooperate.
That is true, and I think what the case law certainly out of the appeals court has said is that absent an adequate explanation for why plea counsel isn't there and testifying and hasn't provided an affidavit, it supports a negative inference against the defendant. And here, there's not only an adequate explanation about why he's not there, it actually undermines any claim under the first prong of Safarian.
But you want us to draw the inference that the client told the lawyer he was a citizen?
Yes, I don't think it's an inference. I believe that's a representation by the defendant's agent at a motion hearing attributable to the defendant. There's no reason why he shouldn't be bound by that representation.
Well, I've read it in context. That's not a fair description. It's one of, he went back and forth, defense counsel, and trying to explain, and defense counsel was trying to get him to attest to it. He wouldn't attest to it. Maybe he's not attesting to it because it ain't true.
Motion counsel specifically says in the motion hearing that there are emails from defense counsel to CPCS stating that the defendant told him
But
he was a citizen.
none of this is testimony, right?
None of it is testimony. That's
All right,
correct.
I think that's.
And I don't need to press that too hard. I do think that the judge erred as a matter of law in crediting the affidavit, but even if you want to credit the affidavit, even if you want to assume for the sake of argument that prong one was satisfied, the motion was still properly denied because the defendant cannot establish those special circumstances and cannot establish prejudice more broadly.
Well, the stakes of going to trial, though, and not getting the benefits of the plea bargain are not really draconian here. Obviously, there could have been a 2.5 and a 2.5 from and after, which has a 2-year parole eligibility. But over the course of a significant amount of time, it's very unusual to see on a plea anything more than 1 day on the underlying distribution of possession with intent. So you're really probably looking at 2 years and a day. And if it's a really big deal, not to go back to someplace you've never really spent any significant time in, there's turmoil there, you don't speak the language. The differential here is not draconian.
Well, if I heard Your Honor correctly, I think what you said was the difference on a plea is a day on the distribution, but that's getting the credit for accepting responsibility. And I think the statistics that defendant cites in his reply brief, I looked at them and they don't seem to differentiate. They have the same 1-day thing between school zone and underlying distribution sentences after trial and at plea. And here the idea is, this defendant had sold 5 times to an undercover officer, both marijuana and cocaine, and repeatedly attempted to sell more marijuana and cocaine. If he hadn't accepted responsibility and he had gone to trial, there's every reason to believe that he could have gotten although it's rare, a consecutive stacked sentence in the district court. And that's not...
But remind me, it's been a long time, but I think, if my memory is correct, the 2.5 and 2.5 from and after actually doesn't have half-time parole eligibility, but has a parole eligibility of 2 years. But even 30 months, juxtaposed against the circumstances of being deported, I mean, that's might well be special circumstances of substantial weight.
But I believe we have to compare apples to apples, and so the parole eligibility of the sentence he took at 18 months would be compared to the parole eligibility of any ultimate sentence. And in this court's jurisprudence, in cases where they talk about the sentence, we don't break it down that way because, if it's a 5-year sentence in De Jesus for the trafficking, whatever the parole eligibility would be on that's what we're comparing. So he had parole eligibility theoretically at 9 months, and that's the differential that we're looking at. And I think, as Chief Justice Gantz noted in one of the footnotes in Lavernenko, the defendant also has to consider the risk that he's going to get the maximum allowable sentence under the law. And as this court also observed in Commonwealth versus Clark, pointing out that on a school zone, it's 2 years in the district court, the court even pointed out what it would be if indicted. And I think we can try to guess at what his sentence might have been. And it's been a long time since I was in the district courts. I can't tell you what it would have been. But the factors we have to consider are that he faced 4 separate school zones. They could have been stacked consecutively, but even if they weren't, they have to be stacked consecutively with the underlying distributions. If he doesn't accept responsibility on the plea, he has a record of previous convictions in which he's had the benefit of continuations without a finding, violated, and already served committed time. All that's going to be before the sentencing judge post-trial if the defendant doesn't accept responsibility and accept this plea. And his exposure could be 4, 4.5, or as you noted, Justice Lowey, 5 years. And that's, if you want to do the parole eligibility, it's 9 months versus 3.5 years or however it stacks out. But that's a significant differential. And I think the defendant cannot rely on Jay Lee. Jay Lee is a case that has a very narrow holding. Chief Justice Roberts was pushing back against the Sixth Circuit's contention that if you face almost certain conviction, as this defendant did, that it should be automatic that you can't establish prejudice. And he said, no, it's not automatic. And what Jay Lee teaches, 1, if there's contemporaneous evidence that immigration was the determinative issue for the defendant, 2, if he has strong ties to this country and no other, and 3, if the consequences of going to trial are not markedly harsher than pleading, then it's not irrational to roll the dice, even if you face almost certain conviction. But he made certain, and he made it explicit, that that's going to rarely be the case. A defendant facing long odds at trial will rarely be able to establish prejudice. And the defendant just cannot satisfy those criteria here. With respect to the contemporaneous evidence, The defendant got alien warnings from the judge, and they were on the green sheet, and he betrayed no reaction. There's no contemporaneous evidence that immigration was an important issue to him, as you would expect if he actually believed that he was a U.S. citizen and if it was a determinative issue. You contrast that with Jay Lee, who, when he gets his immigration warning, he stops and seeks assurances from his counsel and only proceeds when counsel says, "Don't worry, that's a standard warning." In terms of the defendant's ties to this country, it's unfortunate, but he had no meaningful connections. He was cut off and estranged from his immediate family here. You contrast that to Jay Lee, who was the only one who could care for his elderly U.S. citizen parents. And that's also in contrast to numerous cases out of Massachusetts from this court and the appeals court, where defendants had wives, children, grandkids, the kind of long-term, meaningful relationships of mutual support, affection, and obligation that would make it rational to risk increased incarceration on almost certain conviction to stay in this country. He had no legitimate, steady employment. Again, contrast to Jay Lee, who had established 2 businesses in the United States and was apparently so integral to running them that his sentence was initially deferred so he could continue to manage them over the holidays. Again, also contrast to multiple cases in this Commonwealth, where we have defendants who have steady employment or, as in Balthazar, a licensed aircraft mechanic. And I want to make it clear, I'm not saying that the defendant has to earn his place in the United States or that this is a merits-based assessment. To borrow Chief Justice Gantz's language from Lavernenko, it's a question of whether the defendant has roots of sufficient depth and quality to make it rational to risk increased incarceration to stay in this country. And the defendant doesn't.
That doesn't sound like an issue of law to me.
I think the initial factual findings, I agree with my brother, would be, and I agree with the amicus, if there's a substantial showing, there can be an evidentiary hearing, and the judge can find the facts. I think what it seems like the judge did here is assuming that the facts in the affidavits are true. And I think the judge also probably credited much of motion counsel's representation at the motion hearing. He did allow her to make those representations, and that even if you credit those aren't going to be sufficient. So there's no point having a motion hearing, but the defendant can't establish his burden.
Is it not a special circumstance that the defendant is returning to a place he has not been since he was 7 years old?
I believe that is a factor, but as you yourself noted, even establishing special circumstances isn't necessarily dispositive, but that has to be weighed in the totality of the circumstances. And so even if you credit the representation that he hasn't returned.
Well, I understand that, but the judge said that there were no special circumstances. So is that not an error of law that there were no special circumstances? I understand your position that the judge could have said that is a special circumstances, but I find in the totality that it does not rise to the level that would warrant a new trial. But don't we have to remand where he said that was not a special circumstance?
I believe what the judge says in his decision is he goes through, he cites the impassioned advocacy of the defendant's attorney, and he cites the defendant's abuse at the hands of his father and lack of family ties in the home country, and he says he doesn't find the presence of any special circumstances that would support the conclusion that he would have placed any more emphasis. He's not saying that I didn't hear these things or I don't recognize them. He is making the legal determination, which of course this court can review, that it's not sufficient.
But the judge did not even make reference to the issue of age. He spoke about the history of abuse at the hands of the father, which I think we can all agree is irrelevant here. He spoke about a lack of family in Haiti. He didn't mention the fact that he will be returning to a country he has not been since he was 7 years old.
He does not seem to have mentioned that, no. But I don't think that changes the ultimate conclusion, especially where the defendant exaggerates now the lack of his connections to Haiti, repeatedly saying that he has an extreme language barrier when what was before the motion judge was that he has a limited command of Haitian Creole and does not speak French well. So the motion judge might have thought that he can get by there. Also, the explicit representation that Justice Agnes seems to have put into the record for the first time that the defendant's mother and brother had died was not before the motion judge, and instead he heard representations from counsel the defendant's mother was alive in Haiti. So there could be good reason why he didn't emphasize the lack of connections to Haiti. But even if you go beyond, you want to assume for the sake of argument again that the defendant could establish some special circumstances, there's no case, not Jay Lee or any other case, that supports the proposition that it's rational to reject the plea. And again, it's a reasonable person standard, not the defendant himself, but an objectively rational to reject a plea when you face almost certain conviction if you're already removable. And I think the cases I cite in my brief established that he had removal exposure beyond any reasonable dispute. They postdate the BIA cases cited in the defendant's brief. If I could just finish this point, I see my time is out. And they are specific to the Massachusetts offenses. Viveros is a First Circuit case talking about Massachusetts shoplifting. Commonwealth versus Cano is an appeals court case talking about shoplifting. DeFaria is a First Circuit case where the B&E in issue, based on footnote 6, you can tell it's a Massachusetts breaking and entering. And our resisting statute requires someone to use threat of force or violence or risk of injury to knowingly interfere. There's a scienter requirement. The cases I cite establish that these would be considered crimes involving moral turpitude. And whether he would have defenses or not, these show that immigration authorities have moved on that basis. Immigration judges have allowed it. The BIA has allowed it, and it's gone all the way to the First Circuit.
Let me ask you what I asked your brother. Does the fact that Haitians enjoy temporary protected status as of the date of the plea as a result of the Haitian earthquake, is that a special circumstance too?
I believe that it could be a special circumstance if it was put before the motion judge, but we're in a position where you'd be putting a quasi-factual legal representation to reverse a motion judge that wasn't before him, and I think under Commonwealth versus Betancourt, that's not something that the court is normally inclined to do.
Well, let me ask you this along those lines. I wanted to ask you anyway whether we can take judicial notice, as I think we can, as to what the parole eligibility would be in the district court on a maximum consecutive sentence. Could we take judicial notice as it relates to the circumstances with the earthquake and Haitian refugees?
I don't believe so, unless we could. There might be certain things, certain aspects of that you could take judicial notice of, but to the extent that not every single Haitian refugee is similarly situated, there could be factual distinctions. I honestly don't know. This hasn't been part of the record, but I'm just not sure that would be appropriate. It's the kind of thing that should be before the fact finder first. And I do believe, to answer a question that had been asked of my brother, I don't think this court in an immigration case has ever allowed a previously denied motion for new trial on appeal. And so that although we don't think that's appropriate, if you were inclined to reverse, it would have to be a remand for an evidentiary hearing. There are factual issues, and I think the amicus brief does a good job of showing that we have a right to challenge some of those things. We might not have thought it was sufficient to meet the burden and that it could have been denied on the papers, but that it can't be allowed on the papers. And I would finally note that Commonwealth versus Bradley, I believe, was decided in 2013. And while on a retrial, it might mean that we have to reevaluate the viability of the school zone, I don't believe that's a relevant factor for the defendant's plea calculus in October of 2012, where the case hadn't yet been decided and the court hadn't yet clarified the retroactivity.
All right, thank you.
Thank you, Your Honor.